is real property, then we use deed. Okay, and in California, we have different types. Christine, it's here. Okay. Almost full house, huh, for the day. Really appreciate it. Okay, so in California, anybody knows? In California, if you purchase a house, single-family home, or condominium, or any residence, what's the name of the deed? If you can give me the answer, then I will give you more.
Grand deed.
Heard about that, right? Grand deed, right? Grand deed is very, very popular in California, but same thing, same caveat, okay? California is a very, very few state, it's minority in the United States, we use grand deed. Be careful, okay? Compared to another state, especially in the East Coast, they use warranty deed. We don't see warranty deed, okay? So just give you a comparison. In California, we say we receive grand deed. And compared to another state, the majority state, the majority in the United States, they use warranty. Almost same function, okay, the same purpose to prove the title transfer from one party to another party. All right, that's called deed. All right. So grand deed is very, very popular in California, and we will not get involved to tell you the difference because there's too remote. I don't want to get involved. Just need to know in California, as the buyer, we receive grand deed. Okay. And usually not necessary, but usually in California, we complete our transaction through the escrow company. Heard about that, right? Title company, escrow company. It is not required by law, but usually that is a very common practice in California. And compared to grand deed in California, you heard about quick claim deed ever? Heard about that? Heard about this? Quick claim. The major difference is, okay, let me put it this way. Both of them are legal, by the way. Both of them are lawful, right, to use. However, be careful, okay? If you were the buyer and you pay something, you pay some valuable item to acquire this property, don't accept quick claim deed. Do not accept, you insist you would like to accept grand deed. And the reason why is the grand deed provide the minimum warranty on it. Okay? By law, grand deed will provide you 2 warranties. Number 1, even seller didn't say so, okay? But by law, if seller give you the grand deed, seller promise you, number 1, seller never transfer the same property to somebody else. You are the only one. Okay? Number 2, if there were any item affect the legal right, the seller will come out to defense for you. That is under the grand deed. Okay? But if you receive quick claim deed, no any warranty, nothing. You are totally on risk by yourself. Alright? So let me put it this way, okay? In California, you may see quick claim deed, but more commonly that is between husband and wife. Between husband, say for example, husband waive his 50%, half interest on the property. Why? Because in California, did I mention this to you ever? In California, we are community property. We are one of the community. There are total 9 states in the United States. We are one of the 9 states. We are in community property state. That means after the legal marriage, husband and wife, either side acquire the property in California, then husband and wife take 50-50. That including the salary, including the lottery, including, you know, everything, including everything. So, yeah. The sad news, the very sad news is, if you heard about them, you know, the sad news is when people got the very large amount of lottery, and usually they got divorced. This is very sad. This is very sad. So, anyway, that's kind of a joke. Okay. So, in California, after marriage, okay, so every property acquired after marriage, it becomes 50-50. So if the husband and wife say, okay, I don't want to take half, that's yours, then the party waive the 50%, just sign the quicken deed to the other party. All right. So let me put it this way. Okay, why quicken deed is so important for the husband and wife? Because after the marriage, if one party acquired the real estate and on the grantee only one person's name there, however the acquiring day is after the marriage day, even on the grantee only one person's name there, but the other person still take 50%. Unless the person's name on the grantee can present the quicken deed signed by the other party. Then this person, his or her name on the grantee, will take 100%. Otherwise, you can only, you know, keep like 50%. So quicken deed, number 1, don't use it if you purchase from somebody else. Number 2 is more commonly used between husband and wife. All right, and especially when one party waive his or her 50%, and the waiving party sign off quicken deed. Okay, am I clear? The third one may also you heard about that. It's called interspousal. Interspousal deed. Anybody heard about that? Everybody ever use it? No? Okay. Yes, go back to my original introduction, right? In California, we are community property state, right? So that means after the marriage, every property acquired, it belongs to 50-50. However, the husband and wife can always arrange according to their plan. So building A, 50-50, building B, 100% to wife, building C, 25% to wife, 75% to husband, and building D, 100% to husband. It's okay. It's okay. You don't have to follow the law, all right? However, you can skip quicken deed. You can skip. You can just go ahead and use interspousal. So interspousal deed is used when husband and wife, for example, okay, transfer from one person to both. Say for example, the property was before the marriage. So before the marriage, that is a separate property, 100%. However, after marriage, this person say, okay, this is fine. I just transfer from my name to under our both name. So that's the first scenario from 1% to 2%. Or flip around from 2% to 1%. Understand? So for this scenario, it's very similar to Quicken D. From both party to only one party. Alright? See? So this is number 2 scenario. Number 3 scenario is from 1% totally to another person. See? See? But make the whole thing more complicated. Make the whole thing more complicated. In California, there are at least 4 different time methods to hold the title. Okay, maybe you heard about that. So by default, it's called community property. If you don't do any other selection for married couple, by law, default, that is community property. 50-50. 50-50, all right? Good or bad? Not necessarily is really bad. Okay. Let me tell you why. My idea is good. So let me give you 4. Okay. Number 3 is number 1, where the right of survivorship. Number 4, there is tenants in common. Of course, you can create an LLC. No, I'm not talking about. Okay, you can create a limited liability company. Okay, but it's beyond the scope. So in California, for husband and wife, they may have 4 different type selection to hold the title. Oh, of course, I did not mention the separate property. Separate property just only one person to hold the title. I'm talking about they join. Okay, they co-own. So if they want to co-own the property, there are 4 different type methods they can consider. Let me tell you each pro and con. Okay? Then you know which one is the best for you. So the number 1, consider, say, we don't do anything. So when the husband and wife purchase a property, and finally they went to the escrow company, and sitting there, signing off, the whole pile of the paper, and they would never know what they are. They just sign, right? And at one point, the escrow company, the escrow officer may ask them, what kind of title you want to hold? And they are sitting there and just stunned. And they say, what are you talking about? And at that moment, is eventually, if you don't know any knowledge about this, it's very difficult point. Why? Because the escrow officer cannot provide you any advice. Because this is the practice of law. They cannot teach you what each really mean. So you better off know right now. Okay. So community property is default by law. The good thing is 50-50. That is good thing. Alright? Doesn't matter which party pay. Alright? Doesn't matter, that is not an issue. Once the property is held under the title of community property, it becomes 50-50, and then husband and wife may consider to set out the will or not. That is their choice. When we say will, including living trust, let me put it this way. Okay, living trust. I will not get too much detail about the living trust. However, if the couple did not set out the will or living trust, if one party pass away, that 50% all the way goes to surviving party. Understood? And that doesn't sound too bad. However, if this is a second marriage, it may cause the trouble. Because if the party passes away, survived by children, then those children will not share anything. So this is important. Let me slow down a little bit, okay? Okay, community property, it is not bad. It is not bad. However, keep this in your mind. If husband and wife holding the title as community property, as a lawyer, I will highly recommend set up living trust. If there is no living trust been set, if one party die, the 50% all the way goes to the surviving party. Even though it does not sound too much wrong, however, if this is the second, third, fourth, fifth marriage, okay, the party die, cannot leave the share to his or her offspring. So there's no heirs. Right? So if the marriage is the second marriage, so I think highly recommend this couple set up the living trust. And each party may be able to designate different beneficiaries. Say the husband would like to designate the 50% to his children or parents, whoever, or the wife, same thing, designate her children or parents or sibling, whatever. So if husband and wife holding the title under the community property, I highly recommend set up living trust. Yes, Maria?
How does that work? We're talking about the surviving parties, and there's the second marriage, and there's some children involved in the first marriage. We're talking about next of kin. Who should we pick up first?
Okay, so in your scenario, I want to ask whether or not there is living trust. No or yes? You need to give me one scenario because each scenario has different consequence.
Oh, I was just trying to think that back in the back of my head. I'm never involved with marriages, so I don't know.
For the single person, okay, for the unmarried person, still I recommend living trust. Still, because the living trust is one very important instrument to avoid probate. You know, every year, for some reason, I will take one or two cases for probate. Say, for example, one single person passed away, and then without any living trust, and the whole property will go through the whole legal procedure. And finally, after almost like a year and a half, the judge give you the stamp, say, okay, we recognize who is the legal heir, and that person can take away. You cost the money, you waste the time. So even, you know, for the unmarried people, I will still recommend to set up the living trust, because the living trust by itself will specify who is the heir, who is the beneficiary, and that person will take away the property without the legal procedure. All right? So everybody clear? So for community property, so there are two scenarios. One is without the living trust. If there is no living trust, then the surviving spouse take everything. Sounds not bad, but it may conflict to the party who passed away but survived by the heir. All right? So better off setting up the living trust or will. This is the The good thing, another good thing for this, if the title is held under the community property, 50-50, however, the property must signed by both parties in order to transfer. Understand? That's very important, because if you own the property with another person, you don't want to see the surprise, right? You don't want to see this surprise because in your perception, you always thought your co-owner is Mr. A, but all of a sudden your co-owner becomes Miss B. Because under the joint tenant, I will compare to joint tenant. If husband and wife holding the title as joint tenant, each party can transfer his or her 50% to anybody else without the notice. Without the notice. That is very risky. That is very risky. So if you want to protect your marriage property, company property is far better. Company property is far better. However, the bad thing for company property is if there is no living trust being set and one party die, you need to go through probate. That's very, very inconvenient. It's very, very inconvenient. So if the people they are holding company property, remember, highly, highly recommend set up living trust. Compared to joint tenants, the good thing for joint tenant is no probate. You go wrong, you skip the probate. So compared to joint tenant and company property, so say for example, this couple under company property, but no any living trust, and so if one party die, they need to go through probate. But if this couple under the title joint tenant, and of course no will, if one party die, surviving spouse take away without probate. So it's very, very cost saving. Very, very cost saving. You don't need to spend money to set out the living trust. So some people say, I never done this survey, but some people say in California, joint tenants is the majority. Most of the couple, they choose joint tenant. And only reason is for convenience. This is it, for cost saving, alright? But the bad thing is, I just mentioned, if this couple entered into as a joint tenant, but down the road, either party may transfer to anybody else without approval, without a notice from the other party. So that's a risk. So think about this. Husband and wife originally owned the property under the joint tenant, no problem. But up until one time, for no any reason, or for any reason we cannot recognize or we cannot think about it, husband or wife just transfer his or her 50% to anybody else, and they even don't know it to each other. You know what? This property may never transferable. May never transferable because 150%, and eventually on the free market, nobody gonna buy your 50%. I may take it as a gift for free, right? From Mr. A transfer Miss B, probably just for free. Of course, Miss B will take it. However, if anybody want to pay money to Miss B, no way. How should I pay money for 50%, right? And a lot of lawsuits gonna maybe get involved. So this is a big problem for joint tenant. But anyway, this type of holding title is still the majority for husband and wife. And also, joint tenant may apply to anybody else, not limit to husband and wife. Community property only limit to husband and wife or domestic partner. In California, we have a domestic partner, say means same sex. They just register with the state. So community property only reserved either to legal husband and wife or legal domestic partner. But compared to joint tenants, could apply to anybody. Parent, children, brother, sibling, or just friends. But be very careful, okay? Be very careful. Don't use joint tenants, okay? Be very careful. If you want to use joint tenants, better off talk to the lawyer before you do that. The third one is the number one, combined with number two. Number one combined with number two. It's called community property with the right of survivorship. That is basically is community property. However, you don't set out the living trust. If one party die, no probate.
Then we just number 2.
You mean what?
I mean, number 3 is
Number 3 is number 1 plus number 2. So number 3 is number 1 plus number 2. Why? Because if for the original number 1, you either set out the living trust or no, right? Either way, right? However, if there's no living trust being set, one party die, you need to go through the probate. So combine this problem with number 2, you choose number 3. So husband, wife, if one party die, if it is under the community property with the right of survivorship, you don't have a living trust. But one party die, you don't go through probate, so you solve the problem. Number 1. But again, this only reserved for the husband, wife, or legal domestic partner, not for everyone. Number 2 is for everyone, but don't use it. Okay? It's very risky. And the very last one is for everybody, tenants in common. Everybody can use it. Okay. But be careful, okay? For number 1, 50-50, right? Number 2, allowed up to 4 owners, cannot be more than 4. Okay? So cannot be more than like 5 or 6 owners. So only limit up to number 4. Alright? However, if you choose the joint tenants, each party become equal. Each party under the joint tenant must be equal. There's no large one, no small one. Doesn't matter who paid the money. So if you choose joint tenant, if there are 3 person, three person there, it must be 1/3, 1/3, 1/3. And number 3 is also 50-50. Only the number 4, tenants in common, you may have different allocation. You may have say even 1%, 99% compared to 1%. So number 4 probably is for the regular people. However, if you are investor, if you choose number 4, I say you better off choose LLC, limited liability company. Because if you choose limited liability company, then you can take more than 4 people. Alright? So again, if you are investor, you want to combine your money with somebody else to do the investment. And if you want to go into the, we said it's a TIC, okay? Tenants in common. Okay, if you want to consider the tenants in common, then I would recommend skip this. You set out limited liability company. We talked about that, right? A few weeks ago. It's much better than TIC. Any questions?
For the community property, you said after marriage, then by law it's going to be 50-50. Like if there's like situation like if they purchase their property, but then they got into like divorce, and there's like a separation date. So the community property is like after separation date. I mean, after if they purchase the property after separation date, is that going to be community property or like no?
Separate property. But be careful. Let me repeat. Let me repeat her questions. Okay. In California, the community property period is from the day marriage till the day separation. Okay. Separation is not the same day as divorce. Okay, just give you common sense. Separation day usually is 6 months prior to the legal final divorce day. Usually, separation day is the day people file the petition. We don't say this is a lawsuit. Okay? It is a lawsuit. We just change the name. We say the petition. Okay. Either party can file the petition, right? So the day file the petition with the court, the day usually becomes separation. Usually, not necessary. Usually, people, if you even can prove, before the filing day, your party already separate, you can use early date. But usually, the filing day is the separation date. That really means from that day on, even though your marriage is still there. However, your property divided. From the separation day, the money you earn from salary, from the lottery you won, it becomes separate property. So they also include after separation day you purchase real estate. But be careful. Even after separation day, if one party purchase real estate, you must use your own separate property to do the purchase. So that is the tough part. How can you maintain your separate property all the way through your marriage? It is workable, by the way. It is workable. However, if you use your joint account to purchase the property even after separation day, still that is complete property. So that's argument really arise from, usually. So did I answer your questions?
Yeah, just one more, like, if they both sign for the property, then it's going to be a community property?
Yes.
Okay.
Yes.
And for the joint tenants, can you put like children name
Yes.
on that one?
Yes. Another very common type for joint tenants, that is parents and the children. So other than the husband wife, okay. Second commonly used for joint tenants, that is parent with children. So remember, right? The benefit is you skip probate, and then you don't spend the money to set out the living trust. So the joint tenant is always the cost-saving method to hold the title. So between the husband wife and also among the parents and children, and probably among siblings, probably, but no more beyond. I do not recommend everything beyond sibling.
So if that way, going to say like when parents died, usually when you leave some money or thing to your children, they have to pay tax. If you are joint tenant.
Oh no. Doesn't matter. Right now we don't care about the tax anymore, because right now you all understand. Right now state tax is being raised to $5 million for each person. So I don't care about. So joint tenant eventually is the way to go around probate, not to save the state tax. So we don't have too much state tax consideration right now. So don't worry about that.
The joint tenant just allow up to 4 people. So
Yeah, joint tenant is up to 4 people. So parent, husband, wife, father, mother, and 2 children usually. Yeah, you cannot put in too many people there. That's not very, very rigid, okay? 4 people is not really very rigid. If you have very good reason to explain, maybe the county may allow you to do that. But usually they will say what's more than 4.